Video clipping was shown to us in which it has seen that one person was stamping the photograph of honorable judge with his feet. Therefore, when the rule was issued by your lordships, my lord, with great respect, your lordships did not have power. Maybe as a special bench. My lord, we have served with a rule of contempt by issued by your lordships. We have served with the copies of the applications or affidavits. We have served with the orders of this honorable court, but we have not served with the order of the honorable Chief Justice. But I have just for 2 minutes I have.
You want to see that order?
Kunal Ghosh, kindly take this order first.
এই বেঞ্চটা যে কনস্টিটিউট করে চিফ জাস্টিস যেটা দিয়েছেন সেটা কোথায় আছে?
Bench is not.
What our understanding is, certain affidavits were placed before the Honorable the Chief Justice, who took suo motu cognizance.
What is suo motu?
Court on its own motion.
Oh, no, kindly see this. And own motion means what? I am coming to that one after another. But the entire order is not with me. Miller, kindly just read with the order. Certain allegations as so and so have been made.
এক কপি আছে?
Let me read it, Miller, first. Lay before the Honorable the Chief Justice. They relates to CRS so and so filed with the leave of the Honorable the Chief Justice and Honorable Justice Choitali Bhattacharjee on 28th April 2025. Both the affidavits are related to the acts of obstruction of justice, intimidation of advocates, scandalizing of the court, and interference with the administration of justice committed on 25th April 2025 at 10 Kiran Shankar Rai Road, Kolkata, so and hence praying for taking up the matters as suo motu proceedings for criminal contempt under the Contempt of Courts Act 1971. There were affidavits were there. Both the affidavits are filed against Raju Das, Subhendu Das, and Atanu Rai by one Amitabh Ghosh and another by one Tapas Maitra. The matters are most humbly placed before a lordships for appropriate order. Therefore, who has written Samrat Gupta, officer on special duty, to the Honorable the Chief Justice, 28th April, matter was placed before the Chief Justice. The matter was mentioned before the courtroom number 1 today, 28th April 2025, by several learned advocates who were informed in their submissions that the incidents which occurred on 25th April 2025 at Kiran Shankar Rai Road, Kolkata 7-1 is a clear interference to the administration of justice and a threat meted out to the judiciary and the learned members of the bar. Video clipping was shown to us in which it has seen that one person was stamping the photograph of honorable judge with his feet. The interview given to the concerned YouTube channel was translated and explained to the undersigned in English, from which it appears prima facie. Just the prima facie stamp is so and so. The interview was given to the concerned and explained to the undersigned in English, from which it appears from prima facie clear the person was mentioning about the names of the honorable judges present and past. There was also mention about orders passed by the Honorable Supreme Court and the names of the senior advocates were also taken. Thus, I am convinced, that the matter requires immediate attention to protect the image of the judiciary from spurious and baseless allegations. Hence, I deem it appropriate to constitute the following special bench, comprising 1, the Honorable Justice Honorable Rijit Banerjee, 2, the Honorable Justice Subhoshachi Bhattacharjee, and 3, the Honorable Justice Rajeshri Bhattacharjee. Excuse me, kindly excuse me. Justice Bharat. The petitions along with note be placed before the Honorable Judge so as to enable the Honorable Special Bench can fix a date for the matter to be listed. 28th April, signed by TV Sivagnanam, Chief Justice. My Lord, before I start anything, I should have said first, I tender my unqualified apology to your Lordship's Court if I have committed any contempt. Then I am good. Before I start, I should have said first this. Therefore, now kindly see, Chief Justice in his administrative capacity has constituted a bench and send it to your this bench to this in his administrative capacity. It was not a judicial order. Then this bench has been constituted to go into the sum and substance. Chief Justice has not said in an administrative order contempt proceeding is initiated or suo motu rule is issued. It cannot be done by a Chief Justice in an administrative capacity. It is not an initiation of a suo motu contempt proceeding by the Chief Justice. This part of the administrative order does not show that contempt proceeding has been initiated under Section 15 of the Contempt of Courts Act. A pure and simple administrative order by the Chief Justice, constituting the bench. Now, my lord, kindly see the Calcutta High Court contempt rule or contempt of court rules 1975. I hope your lordships are having. And your lordships have considered all that rules and issued the rule of contempt. I hope so. It is not there. Calcutta High Court contempt of court rules.
नहीं
I know nahi. Kindly come to the Calcutta High Court contempt of court rules 1975, rule so and so, so and so, so and so. Kindly come first to rule 2. Proceeding in connection with the civil contempt may be initiated by a petition present so and so, it is not required for us. Or by the High Court on its own motion. High Court by its own motion. What is own motion? I'll explain later on, but I think this rule is sufficient for the first category of my submissions. On a reference made to the High Court by the subordinate court as the cause of criminal contempt, proceeding in connection with the criminal contempt may be initiated A. on a motion of the High Court in respect of a contempt committed upon its own view under Section 14 of the Act, not applicable. On its own motion by the High Court under Section 15 subsection of the Act, or C. on a motion founded on a petition presented by the Advocate General under Section 15(1)(a) of the Act, and D. on a motion founded on a petition presented by any other persons with the consent in writing of the Advocate General under Section 15(1)(b) of the Act, on a reference made to the High Courts by the subordinate courts under Section so and so, so and so. There are 3 or 4 categories are there. One of the category is that with the consent of the Advocate General. And second of the category is that court on its own motion. Contempt may be initiated on a motion. Administrative order does not reflect or cannot reflect initiation of any motion. Every petition shall be expressed to be made in the special jurisdiction of this court, provided that every petition for civil contempt shall be expressed to be made in the special civil jurisdiction, and that every petition for criminal contempt in the special criminal jurisdiction. It is under the special criminal jurisdiction. Now, my lord, kindly come straightway. Rule 16. All petitions presented by the Advocate General and all petitions presented by any other persons under Section 15 of the Act shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. All matters relating to contempt subordinate court brought under so and so shall be dealt with by the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time. On that date, when the administrative order was passed, it was not moved before the Chief Justice. Or any other bench determined by the Chief Justice, which is called the jurisdiction. Again, I read. All petitions presented by the advocate, all prescribed by any other person under 50 of the shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. All matters relating to contest of so and so Chief Justice or some other bench as the Chief may from time to time. Next, rule issued by any court on its own motion shall be dealt with by the particular court, provided that such rules under Section 15 of the Act shall be heard and determined by such bench of judges as the Chief Justice may appoint. Rule issued by any court. Rule issued by any court on its own motion shall be dealt with by the particular court, provided that such rules under Section 15 of the Act shall be heard and determined by such bench of judges as the Chief Justice may appoint. 18. Notwithstanding anything contained in Rule 15 to 17 above, the Chief Justice may assign a rule. Chief Justice may assign a rule for hearing before another judge of bench or bench if required in the special circumstances of the case, or if the judge or the bench reports to the Chief Justice for so doing. Therefore, when the Chief Justice can assign a rule. Chief Justice cannot assign a whole content matter to a court, content application. Only a rule, if the rule has been issued by the Chief Justice. No rule has been issued by the Chief Justice and thereafter it has been assigned to a lordship. And my lord, with great respect to your lordships, my lord, kindly do not take me amiss. For all arguments' sake, I will be arguing. Your lordships have no power to issue rule. If a rule has been issued and it has been assigned to your lordships can decide the matter. Therefore, when the rule was issued by your lordships, my lord, with great respect, your lordships did not have power. Maybe it's a special bench.
So that's the first point.
We have to go by the rules.
Yes. So no power, no jurisdiction. Now, second point.
No rule has been issued by the Chief Justice at all. By a competent court as defined as settled by your lordship's court rules. Rule has been issued in this case by the assigned bench, which does not satisfy the requirements of Rule 15. This is my first one. This is my first
Yes,
one.
yes. We have noted.
Shall I proceed?
Yes.
Now, very importantly, your lordships kindly come. In re suo motu proceeding by Honorable Court number 1. What is that suo motu proceeding? What do you mean by suo motu proceeding? When a rule has not been issued, kindly see your lordship's order. Dated 2nd May 2025. What is the proceeding? Tested before the bench. And on the first day it has come before a lordship's court.
2nd May order.
In re suo motu proceeding by the Honorable Court number 1. What he has initiated. What is can the Chief Justice in his administrative side initiate a contempt proceeding? What is that? An administrative side and an order has been passed. It doesn't mean that a judicial court has initiated a suo motu proceeding. But we have seen that.
Yes.
Now see your lordship's kindly address your lordship's order. Mr. Joyanto Mitto, senior so and so, for the petitioners in CRLPP number 7 of 2025. Then your lordship see so and so for the petitioners in CRLPC 6 of 2025. Therefore, after see Mr. Parthasarathi senior so and so for the petitioners in CRLPC of 2025. Then again for the petitioners so and so for the alleged contemners. Therefore, before your lordships, there are petitioners. If there are petitioners, how it can be a suo motu? If the petitioners are there, my lord, in that case, first is consent of the Advocate General is required to be taken.
Yes.
Now your lordships can read the order, paragraph 1. These proceedings for criminal contempt have been initiated suo motu by the court of the Honorable Chief Justice. Where from your lordship have got it? Not the court, but an administrative order. Then, Malaka, we have gone through the materials which have so far been brought on record, including affidavits of person, so and so. We are of the view that the criminal contempt has been committed in this case by the alleged complainants by interfering with the due administration of justice, judiciary. Your lordships have formed your lordships' opinion of committed contempt. What trial, what argument I will make? It is not that prima facie your lordships were satisfied, but your lordships were satisfied. We have the view.
Prima facie, sentence starts with prima facie. Please read,
We
Mr.
have gone through the materials which have so far been brought on record, the affidavits who are present at the place of. We are of the view that the criminal process have been committed by the interfering with the due administration.
Prima facie, it's not there in your.
Oh, yes, yes, prima facie, sorry. Prima facie, we are of the view.
Yes, yes.
Hence, notice be issued. Kindly come to next order. Again, in review of suo motu, so and so, court is on its motion, so and so, so and so, so and so.
No, Shabi, now work with that.
ठीक है तो
Date of the order, next order.
Yes, the order is dated, my lord, 19th May 2025.
That আছে তো নিশ্চয়ই।
Job of the Commissioner of Police be kept with the records. My lord, got it? A report filed on behalf of the Commissioner of Police be kept with the records. Affidavit filed on behalf of the Incorporated Law Society be also retained with the records. By our order dated May 2020, we had order recorded the prima facie. We are satisfied the Commission of Criminal Contempt. We are granted liberty to the alleged contemnants to file their replies within a fortnight from Swansea. Today, all the alleged contemnants are represented through learned advocate. None of them filed the affidavit. The allegations against them remain uncontroverted. There will be rule against the alleged contemnants. The rules are made returnable on January 16. Therefore, rule have been issued by your lordships. With great respect, under our contempt rules, assigned bench has no jurisdiction to issue rule.
Just for our clarification,
Yes, it is
under rule, কোথায় গেল রে বাবা? Under rule 16 doesn't talk of assignment of rule. 17 says rule, 18 says rule.
all petitions, let me read it. All petitions
Yes.
presented by the Advocate General and all petitions presented by any other persons under section 15 of it shall be moved before the bench presided over by the Chief Justice or by such other bench as the Chief Justice may from time to time appoint. On the date it is alleged to be initiated. That day this bench was not existing. Let's assume Chief Justice on a usual days, Chief Justice determination has been given to a bench presided over Justice Arijit Banerjee for the contempt matter. I can understand Justice Arijit Banerjee sitting with Honorable Justice Sukosachi Bhattacharya has taken up the matter. But on the day, determination was with the only Chief Justice. There was only the Chief Justice bench. Bench means court. Where is that order here?
So Banerjee with
This one.
with the leave of Justice
This
Banerjee.
one.
Now here this rule 2A read with rule 17. Can't it be interpreted that there is a distinction between initiation of a contempt proceeding and issuance of a rule? Suppose even in contempt applications, an application is filed, that is the initiation of a contempt proceeding. Subsequently, prima facie being satisfied, we issue a rule. Now, we are speaking against you so that you can.
Yes, my lord, yes.
Now, let us contemplate it like this. 2B empowers the High Court to initiate a contempt proceedings proceedings in connection with a contempt, criminal contempt also, may be initiated by the High Court of its own motion. 2. Rule 2.2. Proceedings in connection with a criminal contempt may be initiated on a motion of the High Court in respect of a contempt. Now, proceeding is initiated by the order of the Honorable Chief Justice, barring your administrative portion, will be coming to that. Proceeding is initiated by the Honorable High Court. Then under section 7, Rule 17, this bench issues a rule. So then Rule 17 says rules issued by any court of its own motion, proceedings initiated by the Chief Justice under 2.2 sent to us, constituted a bench, and then we issue the rule under Rule 17 and we will deal with that. Can't it be interpreted that Chief Justice only initiated the contempt proceedings, but the issue is, the rule is issued by us for the first time?
Let's take it. Who will initiate? A court?
Yes, Chief Justice's court.
Court.
Yes.
But here the court has not initiated.
Can't there be two components of the same order?
No.
Judicial and administrative?
No.
Because-
Administrative order thoroughly, this is different.
All right.
Administrative order cannot be treated as a judicial order.
The first part is that suo motu proceedings has been initiated by the chief.
Why?
And the matter is the bench is assigned.
Madam, may I just,
Yes, please.
may I clear it? My understanding. Court means what? High court means what? If you say high court, then the high court entire all the judges. Or Chief Justice has made a determination. If you say high court, then high court all the judges have to sit and they issue the rule. Or the Chief Justice. Or determination given by the Chief Justice. Therefore, it is very clear it should be a judicial order. But that my argument will make it very clear when I read Rule 17. Assignment is after the issuance of the rule. Make a legal, and I am arguing actually against the judicial, against a person who may be your learned brother in a here, and who is practically my brother in other life.
That has got nothing
Nothing to do.
Absolutely.
But I am sorry. But,
All of
I-
us
No, 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 no. We are on.
this 17 rule has not been assigned. But if we give an effect interpretation of the Rule 2, the way my Lord Justice Bhattacharya is making the observation, then Rule 17 has to be ignored. A statute has to be read whole, not part. Second part, it will take time. Now it is 10 past 1.
Very well.
Next
Next Monday.
From 2 o'clock, I have matters.
Next Monday.
Give some more time, not for half an hour. So
No.
that I can finish it.
Sure about it.
It is not
1 hour. 1 hour.
30 তারিখ হ্যাঁ 30 তারিখ কোনো অসুবিধা নেই
Yes.
তারিখ আমার অসুবিধা কি না না আমি থাকবো না হয়তো
Just
one request I will make, my lord, if your lordships can dispense with the appearance of the contempt.
yes, yes, yes.
Before your lordships do that, but just for a digression, kindly look at the penultimate paragraph of your lordship's order. Which order?
Which order?
Own order,
Our order or Chief Justice's order?
your lordships.
Hmm.
12:30 a.m. they have been directed to appear.
They appeared.
At 12:30 a.m.
Oh, it's all right. Anyway, no,
Taking you from Mr. Bandyopadhyay's argument that it is there at 12:30 a.m. High Court doesn't see it. How can they appear?
Affidavits
I have not given
filed by the alleged contemners
mind to that extent.
in court today.
12:30.
We get with the
Normal
records.
court hour.
Stop. The personal appearance, could you check for the time, of the alleged contemners is dispensed with for the timing upon their undertaking to be present as and when so directed. Paragraph, Mr. Bandyopadhyay, learned senior advocate, representing the respondent number 8 in
CRLCP 7 of 25.
পেয়েছো?
CRLCP 7 of
Begins his argument. So if he does not conclude paragraph, list this matter once again on সামনে সোমবারের ডেট দাও 30 তারিখ, marked 12:15.
12. I will finish by 1:15.
ঠিক আছে, marked
So that
12
we
noon.
finished it.
12 noon, ঠিক আছে।